Friends, today I come again to discuss another case law, very important case law. Karnataka High Court set aside position attachment of Xiaomi India fixed deposits of rupees 3,700 crore rupees. It holds that in the absence of any reasons as to why and how the remand would be defeated by the petitioner, mere apprehension that huge tax demands are likely to be raised for completion of assessments were not sufficient to constitute formation of opinion. For poorly touching excessive FDs, further opinions that order was passed mechanically based on borrowed satisfaction of the investigation. That is very important. That borrowed satisfaction, the word which the High Court has used, of investigation wing and TPO, without independently forming opinion are likely on likely additions to be made during the assessment. Thus, holds that in the sense of fulfilling the precondition of forming independent opinion. In most of cases where we see these days assessing officers just they borrow their opinions from investigation wing or some other wing. They don't form any independent opinion. The order is bald, vague, cryptic, laconic, unreasoned, and no speaking. Directs the assessee to not make any payment in the form of royalty or otherwise to any foreign entity until the conclusion of assessment out of lease FDs. However, grants assessee the liberty to take overdraft on these FDs for paying such foreign entities. Indirectly, you can use it. Also directs the revenue to complete the assessment proceedings for assessment years 1920 to 2122 on or before 31st March 23. For assessment year 1819, revenue issued show cause notice upon the assessee with respect of disallowance of royalty payments made to foreign entities, that is Qualcomm and Beijing Xiaomi. During the pendency of assessment, the revenue passed order under section 281B after obtaining requisite approval for personally attaching assessees FDs amounting to 3,700 crore rupees for a period of 6 months. High Court produces the impugned order under section 281B, wherein revenue noted that as per the findings of the investigation wing and TPO, there is likely additional income of 33,980 crore rupees, resulting in an additional tax liability of 10,434 crore rupees, excluding of international penalty, of course, with respect to assessment years for which assessments are pending, and thus, in order to protect revenue interest, provisional attachment was necessary. High Court remarks that, except for stating that there is a likely addition, no valid or cognate reasons are assigned by the revenue as to why and why the opinion for provisional attachment was formed. Relies on coordinate bench ruling in Indian Minerals and Granite Company, wherein following Supreme Court ruling, other Christian Industries versus State of Himachal Pradesh and others, that is done in the context of CGST Act. It was held that mere apprehension that huge tax demands are likely to be raised on completion of assessment is not sufficient. Is not sufficient for meaning of passing a provisional order of attachment. Accordingly, holds that the impugned order is arbitrary and reflects premeditated conclusion without recording an opinion necessary to attach the property. Holds that the doctrine of proportionality, which is implicated in purpose and necessity of provisional attachment, mandates existence of a live link between need for the attachment and the purpose which it is intended to secure. Points that tangible material to allege the assessee are not likely to fulfill the demand was conspicuously missing and absent in impugned order. Thank you, friends. I will be coming with more case laws. If you like it, good. If you do not like it, please let me know. Please let me know. If it's in liking, it's good. Thank you.